Before we get started, I do want to introduce our attorney, Jillian Pickett, who will be doing our presentation today.
Hi, good morning, everyone.
All right. It doesn't look like anyone else is in the waiting room just yet, so I guess let's get started. I'm going to mute everyone besides Jillian, of course, because she will be our presenter.
All right, hi, I'm Jillian. Today we're going to be going over probate closing options. So generally when we're talking about probate closing options, there's really two options that we're talking about for you to have a choice between, and it's going to be the closing statement versus the complete settlement statement. Next slide, please. Perfect. And again, just a reminder, this presentation is really meant to be a general overview of estate planning. Should not be considered legal advice, and you should always consult an attorney, especially in your state, to determine the legal requirements. This one's going to be a little bit geared toward Massachusetts because that's where we're in. But it's good, it's always good to consult someone in your area. Next slide, please. Okay, so just a little bit of an overview of probate closing. So the probate closing signifies the end of the probate process, and there are two different methods. Both are going to impact timeline, cost, court involvement, and the protection for the people that are involved. So what is a probate closing? It's the final step. It is going to tell the court and all parties involved that all the debts are paid and that the assets are fully distributed. Again, like I said earlier, there's two methods that we're going to dive deeper into. The method really matters because it can affect the timeline, it can affect the cost. Court fees are going to be higher in one, legal fees are going to be higher in one than the other. It's also going to vary how much court oversight is involved as well. So one, a judge is probably going to be very involved in the closing. The other one, it might just be signed off by a magistrate. And it also is going to impact the legal protection for the personal representative in closing out that probate matter. It can also maybe impact the beneficiary in terms of how much information they get from the estate and how much, if they have any complaints about how the estate is being closed out. Just to go over some quick terms that you might hear throughout this time that we're talking together. First one is heirs. So these are people who are going to inherit from the estate if a person does not leave a will. Beneficiaries are those who are named to inherit property in a will. It can maybe also mean heirs if they're the ones inheriting from the property. So heirs and beneficiaries can mean sort of similar things. It's just really the people who are going to be inheriting from the estate in the end. Personal representative, this is the person who administers the estate. They pay the debts, they make all the distributions, sometimes known as an executor or administrator. We use the term personal representative in Massachusetts now, so that'll be the term that we use throughout the presentation. Next slide, please. Okay, now we're getting into our first method of closing. So the first method is really this closing statement. This is going to be an informal way to close the estate. It's going to tell the court that all the debts and taxes are paid, the assets are ready to be distributed to the beneficiaries, and the personal representative in this situation will file what's called a closing statement with the court. It's a short form. It really just signifies what I just said, that all the debts are paid and that it's ready to be distributed, and that an informal accounting was sent to the beneficiaries. Once it goes on file with the court, it's accepted immediately, and the personal representative can make the distribution right away. There's not a court hearing required in this. It's all kind of immediate. You're not getting it reviewed by a judge. So it's really best to use this when the estate's straightforward, there's no disputes, all of the beneficiaries are in agreement, there's not any issues between them. And the heirs or the beneficiaries want a faster, lower cost closing, and unsupervised administration is permitted by the jurisdiction. So this means there could be other reasons why we would need to close formally. It might not be permitted in a situation. So some key requirements are that there's no outstanding debts of the estate. You have to, like I said earlier, you have to send an informal accounting to the beneficiaries to make sure that they know all of the assets that were in the estate and what they are receiving at the end of the distribution. The distributions need to be made in full to the beneficiaries. Usually we like to obtain a sense from the beneficiaries, just saying that they received all of this information, they're in agreement with the closing statement. It's the best practice to have that on file with the court. And then just another note is that the personal representative's liability for this, at least in Massachusetts, is not fully discharged until 1 year after filing the closing statement. During that time period, there's usually nothing the personal representative has to do, but it's really just a waiting period for them. So in that time, someone could bring a claim against the estate if they wanted to, or if they had a valid claim against the personal representative's duty. Usually in a situation like this, there's no such claims that would exist. So the 1 year is really just a waiting period. Do we have any questions so far, Allie?
None so far. As a reminder, if you guys have questions during it, just put it into the chat box and I will ask those questions and Jillian will answer those during the presentation. So any questions so far about closing statements? Don't see anything yet. And we will do questions at the end as well. So if we miss something, we can go back to it at the end.
Yeah, definitely. And we'll go through the kind of comparison as well once we get through both of these.
Yeah.
Perfect. Next slide. Thank you. Perfect. So next one is the complete settlement. So this is going to be considered a formal closing. So the personal representative is going to prepare a full accounting for the court. They're going to tell the court everything that came into the estate, everything that came out of the estate, as well as the final distributions. In this situation, the judge or the assistant judicial case manager in some cases is going to review all of the accounting. They're going to review the fees. They're going to review the distributions. They're going to make sure that everything that was paid out of the estate was paid properly. Any objections in this situation will be heard and resolved by the court. It may involve a court hearing. Massachusetts really tries to push a lot of our probates to not go through hearings. So most of the time they will be allowed administratively, but there can be a court hearing, especially if there's objectors to the first and final accounting, then it's very likely that there's going to be a court hearing. The court, once it reviews everything and is satisfied with the first and final accounting, they issue a final order and judgment, and the estate is formally discharged at the end of it. So this is best used when the estate is complex, if there's creditor disputes that need resolution, if the beneficiaries request the court oversight, maybe if there's some conflict between the beneficiaries, you want to have a first and final accounting approved by the court to make sure that everything is directly approved and final in that final order. It can also just be when the personal representative wants full legal discharge. So if they want a final court order right then that says the estate is closed and that their fiduciary duty is discharged, then this is going to be a better option. You're not going to have that 1 year waiting period. It can also be helpful when there's large estates or if there's unusual assets involved. Oftentimes when there's real estate involved, we usually recommend a complete settlement statement. That way it's just very clear and it allows for clear title to transfer as well. So some key requirements to be able to do this. Again, we need that formal accounting with the court that's really going to tell them everything that came in and everything that came out of the estate. Notice needs to be given to all heirs, beneficiaries, and creditors. Attorney representation is very common in this situation, especially if we're going to have issues with people objecting. You're really going to want to have an attorney for this. The court will often approve the fees and distributions. This can be personal representative fees, it can be legal fees, but they're really going to look at everything that was paid very closely. And like I said, the personal representative's liability is fully discharged immediately upon the court entering that final order and judgment. Next slide, if there's no questions, thank you. So this is just a side-by-side comparison for these two methods of closing. So again, the court involvement for a closing statement, it's really minimal. You really just put it on file with the court. The court's not really looking at it. They're going to look at it and make sure that it's the correct name and all of the correct information, but they're not really going to approve it. A complete settlement may require a hearing. And the judge is really going to be hands-on. And for the most part, I think we might have a question, Allie. Do you want to?
Sorry, I had to unmute myself. Yes, we do have a question. Ruth asked, can a closing statement probate be reopened if an asset is missed?
So yes, a probate is always able to be reopened if an asset is missed, even if you filed a closing statement, even if you had a complete settlement and with a full decree, you can still reopen that probate at any time if you need to be able to gain access to that asset. Perfect. Okay. Um, Timeline for this, the closing statement is very quick. If there's a lot of beneficiaries that we need to gather a sense from, then that can take a little bit longer because we have to do a little bit of mail back and forth with that. But as soon as we get that closing statement on file with the court, it's accepted, the estate is closed, albeit for that 1 year waiting period. Um, for the complete settlement, it can take a long time. We said 3 to 12 months. It really depends on the estate. If you have a fully assented to first and final complete settlement, then it can be pretty quick. If you don't have a fully assented to, it can take a lot longer. If you're filing in Suffolk County in Middlesex or in Massachusetts, it can take much longer than 12 months. It really just depends on the court, on the situation, and how complex the accounting is really. So the cost associated with it for the closing statement, it's going to be a lot lower in court fees. If you're hiring an attorney, it's probably going to be a lower fee for that as well. Um, it's going, so that's really the cost associated with it. Those are really the only two. For a complete settlement, the cost is going to be a lot higher. There's going to be higher court fees, higher attorney fees, as well as you might need a citation, which would require you to publish in a newspaper, which would be additional fees as well. So again, you're just looking at a lot more added expenses to the closing of the estate. For the legal protection for the closing statement, the estate is for the most part closed at the end. Once you put it on file, you can distribute the funds usually with no issues. However, the only thing is that 1 year waiting period that we talked about before, that someone could come up in that time if there was some kind of wrongdoing done. Complete settlement statement for the legal protection. This is going to be your maximum. It's going to be your gold standard. Once you receive that decree from the court, that's a final decree. The personal representative's liability is officially discharged. And it's really just the best protection against any claims for the closing. Dispute resolution for a closing statement. We're not going to have any of that addressed by the court. It's just that piece of paper that's being put on file with the court. For a complete settlement, if someone objects to it, then the court's going to adjudicate that dispute. That's when we're going to have a court hearing. That's going to get a little bit more complicated, again, more expensive as well. Accounting required for the closing. We really want to make sure we're sending that informal or at least a summary to the beneficiaries. Sometimes this can be in the form of something that the client creates for their beneficiaries and heirs. Other times it could be still created by an attorney. Sometimes people just send the bank statements if that's what people really want. It can really be up to you. For the complete settlement, we are required to do a formal court accounting. This means that we have to use the court documents. It has to be in a very specific format, and it has to also be the information in the accounting has to be very specific and to the court standards as well. So best for the closing statement is really going to be best for simple, uncontested estates when they want to close quickly. Complete settlement is going to be great for complex contested estates. And again, there might be other reasons why you would want to do a complete settlement for that full release of liability. Also, maybe if there's real estate involved, that's one that we see a lot. The closing statement, again, the personal representative liability. Some risks still remain, again, in that 1 year period. We're just waiting in that time. And then for a complete settlement, the full discharge is possible because the court's really approving all of the actions that the personal representative took in the time that the estate was open. Any questions? Doesn't look like it. We can go to the next slide. Okay, so this is kind of just a decision framework to help you kind of decide what might be right for you. Again, you always want to contact your attorney. They're going to be able to give you the best advice in terms of what might be the best option for your closing. So if there are disputes among beneficiaries and creditors, you're really going to want to do that complete settlement statement. I think we might have just had a question pop. Okay, perfect. I'll
Yes,
pause.
we did. All right. The question is, what would happen if an estate is closed, the original personal representative has passed away, and a new asset is discovered? Deceased died without a will, and original personal representative was a spouse, no children together. Spouse was the personal representative who died and had children.
I haven't had children. So if everything would be going to the spouse's estate, so what you would have to do is you would have to reopen the estate. The person who would reopen the estate would be the spouse's personal representative because they would be the person with an interest in the property. So that would be the person who would go forward and reopen the estate to get access to that asset. That asset would then go over to the surviving spouse's estate and then be distributed that way, because that's how it would be. That would be the intestate rules. Perfect. Okay. And then, so if there was not a dispute among the creditors or the beneficiaries, then a closing statement may be able to be filed. Does the estate involve complex assets or unclear title? If yes, we want to do a complete settlement. If not, then a closing statement can be adequate. A closing statement can be adequate when there is real estate involved or something like that, but you just want to be really careful with using those when there is real estate involved. And again, when there's other complex assets or unclear title, that might be when you want the complete settlement as well. If the personal representative is seeking full legal discharge, then you're going to want to do a complete settlement statement. The closing statement just provides the basic closure. And again, it's going to take that 1 year waiting period, at least in Massachusetts. Is minimizing time and cost the primary goal? If yes, then you're going to want to do a closing statement because it's really going to save you a lot of time and it's going to be at a much lower cost than the complete settlement. If not, then you could consider the complete settlement for that. Okay. Okay, so here are some key takeaways from this. Both options formally close the probate estate. The difference really lies in the process, cost, time, and the legal protection given to the personal representative. The closing statement is really going to be so much faster, cheaper, and ideal for cooperative and uncomplicated estates. And complete settlement really provides the maximum protection and court-ordered resolution. It's really essential when you're going to have contested cases or complex estates. The personal representative's risk exposure is another key factor. Only a complete settlement offers full discharge as soon as the court issues that final decree. And it's really important that you should consult legal counsel before choosing, because there's jurisdiction-specific rules that may dictate the eligibility for each lesson, for each method. And I know when I talk to my clients about closing the estate, I really go through each of these two options for them, so that they can decide which one's going to be the best one in this case. And you can give better recommendations once you know the estate and you know what's expected for the closing. Any questions? That's the end of our slides. But if anybody has any questions about closing, we're happy to answer any of those.
And you can feel free to unmute yourselves now and ask the questions yourself, or if you feel more comfortable putting your question in the chat, I can ask that, whatever everyone prefers. There's another question. All right. What if there's no family left and no will in place when someone passes?
Yep, this is something that comes up somewhat often, but it's usually the big issue. So someone has heirs out there somewhere is kind of the answer. In Massachusetts, so they're deemed to have died intestate, so it passes by the rules of intestacy of Massachusetts. There is somewhere a first cousin or a first cousin once removed or a second cousin that you need to find in order to administer their estate. The way someone like that would find it, there's a lot of people out there who do genealogy searches and they'll be able to kind of build a family tree, find out where people are living and tell you like who's alive, who their nearest relative is. But it's really going to be the closest relative to them is going to be the person who inherits, and there's someone out there. There's always someone out there is really the answer to that question.
Is it better to leave it paid on death if you leave it to charity?
Either way, I don't know that there's necessarily a better or worse way to do it. If you're looking to avoid probate and avoid probate in general, we're looking for three things. So either there's a joint owner on the account, there's a named beneficiary on the account, or it's in the name of a trust. So that would be one of the options of if you were trying to avoid probate. So I think if you wanted to leave a pay on death to a charity, that's a great way to avoid probate in that sense. Or you could set up a trust that leaves certain funds to charity as well and make that the pay on death beneficiary. Either way, it really just depends on if you want to avoid this probate process, which is a public, expensive proceeding to go through.
Another question. How to deal with debt collection agencies with probate?
Yeah, so it can really vary with them. Some of them will negotiate with you after a person has died if there's a certain debt owed and if there's not enough in the estate, or if you just want to negotiate it down. Some of them will negotiate with you. That's one way to do it. Another thing is, in Massachusetts at least, there are kind of requirements for certain creditors to bring actual claims and get judgments against estates before it's actually an obligation of the estate. So there are ways to kind of get around certain debt collections depending on the process and the type of debt that it is as well. Obviously, if it's a secured debt, then that's different. But certain credit cards and things like that can be held to a different standard, and you may be able to just get rid of them at the close of the estate, depending on the type of debt that it is.
All right. Do we have any other questions? Oh, yes, another one came through. If it's a parent and the debt is under the parent's name, is the child then responsible for that debt?
No, so the debts are the debts of the estate. So unless it was something like a joint ownership or something like that, there could be obviously exceptions within there. But if it's a debt of your parent and that's it, then it's a debt of the estate. So they would have to bring a claim against the estate in order to get that paid usually.
Good question.
I think it's relevant a little bit to the blog that might be coming out this month too. There's going to be a blog on insolvent estates that has to do with when the debts of the estate outweigh the assets of the estate. So you could keep an eye out for that as well. That'll have more information on creditors.
Yep, that's supposed to be coming out next week, so keep your eye out for an email. Is there any other questions? It looks like we are all good. Thank you again, Jillian Pickett, for a lovely presentation. Thank you all for joining us. Again, this will be edited and sent out, the recording of the presentation. Thank you everyone for joining, and I hope you all have a wonderful afternoon.